Elizabeth and James Gilbert versus Poloju. I'm familiar with all of you. Thank y'all for being here. Ms. Poloju is here, and Mr. Savric's here on behalf of the Gilberts, and I believe it's Ms. Poloju's motions. And so, ma'am, you may proceed.
Good afternoon, Your Honor.
Good afternoon.
Before I address the merits of my emergency motion, I would like to request for a preliminary administrative matters. One is if I can request under the Texas Government Code 52.046 for a court record, official court record for this hearing, if it's possible. And second,
you can hold on. Stop for a second. Stop talking for a second. You can request a copy of the transcript from the court reporter, and she'll charge you for it. Okay, but yes, you can. Okay. You can request that.
Oh, thank you.
Okay,
thank you.
The second, everybody's entitled to pay the court reporter, so that's fine.
Okay.
Okay.
I was just not sure when to ask for the record before starting, or yeah.
I understand.
Okay.
I understand. I've been with pro se litigants all morning. This is actually delightful for me because y'all kind of know what you're doing, so I appreciate it.
Okay. The second one is I have been filing a few motions. The first and foremost, I want to ensure the court has immediate administrative access to my evidence. Pursuant to Texas County Law Rule 2.5, I provided electronic working copies. There was a box folder that used to be always sent before. This time I used the old one.
Right, ma'am. Let me just tell you that if you filed something electronically and it's been e-filed, then the court has access to it unless you filed it like 24 hours ago. So that's not even necessary. If you would just please begin with your motion.
Okay.
All right,
then,
thank you.
Thank you. To go more efficiently, I would also request one. Can I share my screen, because
you may do so. Sure.
On one page.
Yes, please.
Okay.
Yes.
Please let me know when you see my screen.
You'll be able to see it when I see it. There we go.
Okay. So I have filed for an emergency motion for protective order, also citing few rules, 192.6A, 192.6B, and 199.2. I know that the court knows all the rules, but I just have it also from my notes that these are for they have some evidentiary basis, and there is a legal intent why I have quoted all the three. And here are my requests for this motion. One is to have the order stay for tomorrow's deposition, in-person deposition. I'm not denying that I will not attend the deposition. I wanted it to be Zoom, requested for a Zoom hearing. And I am also requesting that to cut down the costs and also logistics.
Ma'am, stop for a second. I have already ruled that you have to appear in person on a deposition. So yes. Your attempt to stay discovery on that is denied. You are going to appear for a deposition as scheduled. Next issue.
Your Honor, but both the plaintiffs are not available for reciprocal deposition, and also the opposing counsel has approved for Zoom deposition for the plaintiffs. So that's why my request is, and secondly, my emergency motion began because I did not have a neutral location when I have requested that both parties agree for a neutral location, like a court conference room or a court reporter room. That's when the emergency motion.
Let me stop you for a second. So I'm just going to hit these as we go along. So where in the rules does it say a neutral location?
Your Honor, the neutral location?
Yeah, where are you looking at that? Usually these depositions are taken either, hold on, let me finish talking. You have a tendency to interrupt me, and I don't appreciate it. Depositions are usually taken either at the sponsoring or the host lawyer's office, or at a mediator's office, or at the court reporter's location. I don't know. I will tell you that as a practicing lawyer, I've taken depositions on people's porches before, because that's when they were available, and all the lawyers agreed that was a good place to do it. So the fact that the requesting party wants it at a particular lawyer's office for whatever reason, maybe they have an agreement to share offices, office space, etc. That's not going to be that's denied. You are not going to get, if that's the location that the lawyer wants to host the deposition, that's where it will be. Next issue.
Okay, Your Honor, then the associated legal costs and fee, that they are intertwined, Your Honor. That's why I have raised that concern, and also neutral location like courtroom, conference room, or a court reporter's office are the ones that I have requested. But looks like you are denying that request and directing me to attend. But
you are to attend the deposition where it's been designated. It apparently is in a law office form. It's in someone else's law office. So that's where it'll be. Anything else?
Okay. Okay, Your Honor. The emergency motion, also I have filed a supplemental brief requesting and also citing the Texas Civil Practice and Remembrance Code 38.02. This is for to establish the statutory bar to fee shifting based on documented pre-suit, full tender and rejection. The plaintiff's allowable statutory attorney's fees are capped at 0.
I don't know what you're asking me to do here.
Okay.
What do you want me to do?
Okay, yes, to be more clear from the I see the ultimate driver of opposing counsel's resistance to Zoom, or my concern about artificially hourly billing rate that's being added each time I see an email that the legal fee and attorney fee I should be bearing from the opposing counsel. However, I also see that there is Texas law completely bars this, as I was looking through some of these rules and the courts as proven in. I also have some exhibits that I have supported, Exhibit A and B for my supplemental brief, where the plaintiffs have hired the attorney, but I have only been notified at the end of December, which is December 29th. So there is some there is some timeline issues and a dispute that's going on, and that's why.
Hold on. Let me stop you. You're complaining about attorney's fees, etc. This hearing is not about attorney's fees. This is about you asking for a cessation or an abatement of a deposition. If you want to argue about attorney's fees, that'll be another day when if I rule in favor of a particular party and they're seeking attorney's fees and they're entitled to them, then you can argue about the attorney's fees at that time with any other expert testimony, etc. That is not an issue I'm going to deal with right now. So I just want to get to the main part of whatever you're seeking today. Even though you labeled as an emergency, you're interrupting me again, ma'am, and I'm going to tell you, please don't do that. When someone files something and they put the title emergency on it, doesn't mean it's an emergency. And I'll certainly tell you if I think it is, as I'm looking at it. And I'm not sure I see one here, but I'm going to let you keep going. Okay. So what else are you looking for today? What other remedies are you seeking?
So the second one is about the entire discovery timeline. I have also, as the process of looking at preparing for the deposition, I found that there are some timeline issues within how I was served that Mr. Mitchell Savric is representing. So all this information I was preparing for deposition, but then I came to know when I looked at all these documents that the timeline and some ground rules, how do I request. So that is another reason I have submitted my supplemental brief to the emergency motion.
Okay, that I don't know what timeline your issue is. What is it exactly? What issue are you having?
The timeline that I was looking at is that I came to see that there is actual retention of the counsel October 31st, but I received that on December 29th, which was also a surprise to me. And now when I look back all the documents and responses, it took me longer to understand why, where it is coming up. And I was kind of in a surprised ambush if I look at those timelines.
Thank you,
also found that...
Thank you. Hold on. Thank you, ma'am. There is nothing that I see here as far as a timeline issue, as far as your notice of deposition. So that issue is denied as well. If you're seeking some relief based on timeline, I'm going to have to deny that. What else do you have, ma'am?
The last and final one that I have is that Mr. Savric has given me a written admission of defective order on December 3rd in an email explaining that that following defendant's motion to correct the record, Mr. Savric emailed me admitting that the order allowing my prior counsel withdraw was filed in and signed in a wrong court, Law 2. So,
hold on. I want you to understand that County Court 1 and County Court 2 have the ability to share dockets. We are the same jurisdiction. We have the same authority over these cases. Sometimes Judge Shepard sits for me. Sometimes I sit for Judge Shepard. 1 and 2 are interchangeable. Not the same with other courts. District courts are different. County courts, we have the same jurisdiction, same authority, and we each can trade benches to have a hearing. And so you contesting that is not a valid contest, and I would deny that. If you're objecting to Judge Shepard signing anything, is that what your complaint is?
My first surprise was I did not know that it was filed in Law 2. I have disengaged my prior attorney back in November itself, first week of November. So both things were confusing to me, and I thought that both county courts were different, Law 1 and Law 2. I did not know. I was not aware that it's the same authority.
Well, yeah, we've all got the same authority. When it's originally filed, it's assigned a number, either Court 1 or Court 2. But then as hearings come up and availability, especially for people that are frequent flyers of our courts, sometimes they have multiple hearings in consecutive weeks, and we're able to handle those cases because of whatever level of docket, how many cases we have that day or that week. And so they'll get slotted in. Judge Shepard will hear some of mine. I'll hear some of his. Ultimately, it's still our responsibility as how it turns out. But that's not an issue for this court. And I would encourage you can look at our you can just see how we do things. And that's authorized by the Supreme Court. So anything else?
The only request that I have is that please give me a few days time. I will attend in person. I also request both Gilberts to attend at the same time so that I don't have to, the reporters are set and ground rules. We also follow some standard ground rules, finding neutral place and transcripts from the reporters.
Okay, thank you. Is that it?
Yes, Your Honor.
All right, thank you. Let me hear from the other side. Mr. Savric?
Yeah, Judge, if I may, thank you. I want to speak briefly about that last issue about the County Court 1 and County Court 2. I think her problem was that the order that letting Julie Lane out of the case actually was under the County Court number 2 heading. It wasn't just signed. I tried to tell her that it didn't make a difference, but that I would sign an order ratifying that deal if we needed it or if the court but that's it. I kind of need some help here, and I appreciate the court kind of understanding. Her deposition is set for tomorrow. My client's deposition, that I told her that she, if she wanted to take it in Zoom, is set for tomorrow afternoon. My other client's deposition is actually scheduled for later in this month. So we've had an agreement regarding the dates of scheduling this deposition. And those dates are in play and confirmed. And I want to hear from her today that she's going to get on a plane. There's lots of flights, I've checked, lots of flights for her deposition tomorrow morning. And do it tomorrow morning. We're set for trial on the 15th, I think the 15th of next month. And we've got all the depositions scheduled. This isn't a big case. I mean, it is. I don't mean to mean it to these parties because it's a big case to them, but it's a fairly narrow issue to try at trial. And I don't want to have anything that delays this from going on. This is a repeat of a hearing that we had on this twice. I think we've had it on this. And the court has said this thing's going to be tried in July. And so I worked very hard to set it up. Schedule, and my clients are busy and they work how to juggle their schedule to make it happen. So I want to know if she's coming tomorrow morning because I've got to get ready for this deposition. If she's not going to show, I don't want to waste the attorney's fees on getting ready for tomorrow morning. And this has been noticed since April for tomorrow.
All right. She doesn't have to answer any questions to me about that. I'm just going to say that deposition from people don't show up for depositions, they're subject to sanctions, severe sanctions if need be, if this has been an ongoing issue. There is already an agreement for the depositions to go on tomorrow and then subsequent days via Zoom, even tomorrow, half day Zoom, or whatever it is. But the court's not going to look favorably if parties don't show up on things that they've agreed upon. So I can't say anything further than that. If Ms. Poloju decides that she doesn't want to come tomorrow, I presume that I'm going to have a motion and an order on my desk or on my screen here. So I encourage you to follow what you've agreed to. I encourage you to be ready to go try this case. Ms. Savric, did you seek attorney's fees for this motion or no?
I have not sought attorney's fees for this motion.
Okay.
So,
all right. Well, I'm just curious. All the requests from the defendant's emergency motion protective order is denied. The request to have the defendant's deposition tomorrow by Zoom is denied. I'm going to deny any issue that or complain about the order that was signed on the withdrawal. It might have been incorrectly misnamed or misnumbered on the top of the pleadings. That's an irrelevant one. Well, that can just be cleaned up if it needs to be.
Judge, that's the hearing you have set for next week. Can we take that off the docket? I mean, the issue about that order is set for next week.
Okay, I'd encourage you guys to just look at that. Y'all really probably don't need to have that hearing. I mean, but y'all said it. Y'all want to hear it. Either Judge Shepard, I'll hear it. But if it's just a misnumbered order, that can be corrected administratively if it needs to be, which I don't think it does. I will not find that the plaintiff's rejection of a tender on November 11th bars ongoing accumulation of attorney's fees. I will handle the attorney's fees when the issue comes up at trial. Either I hear it or Shepard hears it or whoever hears it. But that's not going to be determined at this point. So y'all can just kind of put that under a separate basket or hat or whatever. No other relief is going to be granted. Defendant needs to show up for the deposition tomorrow. And I have nothing else to do on this. Mr. Savric, you can send me an order.
I will send you an order. Thank you.
All right. Good luck, everyone.
Thank you.
Y'all are excused.
Thank you.